Children Podcast.
The content of this episode is for educational and advocacy purposes only. All statements made reflect documented filings and communications received by Heather Bendel and the Justice for the Serlick Children team. We encourage all listeners to form their own conclusions based on the evidence presented. No accusations are made without supporting documentation, and all persons are presumed innocent unless proven otherwise through due process.
Good evening, everyone, and welcome to Season 2, Episode 9 of Justice for the Serlick Children podcast. Today is Saturday, June 6, 2026, and tonight we'll be discussing my petition for leave to appeal to Illinois Supreme Court and other updates.
Yeah, and we'll sort of explain what that means because it sounds like a bunch of legal mumbo jumbo, and it certainly took us a while to figure out all the rules and understanding what it is. But basically, you're asking the court for permission to appeal to the court.
Yep. So just so everyone is aware, we are trying out StreamYard software for the first time.
Yep.
Previously, we had a lot of issues with chirping throughout our Facebook Lives using the OBS software. So we're trying something new. So hopefully there are no chirping sounds or distortions or anything in this episode.
Yeah, if anybody hears chirping, try to put it into the comments so we can see. And then otherwise, we're just testing this new software, but it allows us to stream to multiple platforms all at the same time. So right now you can watch us on Heather's Facebook, the Justice for the Serlick Children Facebook page, as well as the Justice for the Serlick Children YouTube page. They're all live simultaneously right now.
That's correct. So I have been extremely busy, as have you.
Yep.
Our last episode was April 19th, I believe, and it is now June. So what have we been doing?
Well, this year has just been flying by.
Yeah.
Obviously, you were busy teaching and finishing up the year.
Yep.
You did some really cool stuff with your students toward the end of the year there.
So April 19th, that was before my starfish dissection lab.
Yeah.
So if you haven't previously heard through my social media or previous episode, I had applied for, back in February, a teacher impact grant for $3,000 to do something really cool in my marine science classrooms. I had 6 class periods for a total of 160 students. And I was, on April 6th, awarded with $3,000 from Duke Energy through OCPS Foundation. And then April 28th, we actually did the starfish dissection lab, and I am so proud to say that my high schoolers did amazing. A majority of them had never even done a dissection before. I certainly have never dissected a starfish. Being in high school, we didn't do stuff like that. So I just had a blast with my students. And then after that, we were gearing up for the common final exam, the CFE. And then I was in our high school graduation at the Kia Center.
Yeah,
that was really cool.
And this whole time while you've been doing that, I've been studying for my CFP and CHFC. I am actually taking my exam for the CHFC on Tuesday of this week. So we'll add some more letters after my name for Chartered Financial Consultant.
Yeah, and I actually just completed, after 1 year, I started it just over 1 year ago. And literally 1 year to the T, I submitted my capstone project and I did the practice exam for my 15 credit hour paralegal certification online through my alma mater, UW Parkside. So I should be getting the certificate of completion for that 15 credit hour course in the next few days here, I would think. And I also requested my voucher for my NALA exam here in Florida.
Yeah. And once you pass the NALA exam, you're actually a certified paralegal.
Correct. There's 2 parts to the NALA exam. One is the knowledge portion, which is 150 questions. I believe they're multiple choice. And then there is a written portion where you read through a case and then you have to type it all out. And then I find out if I pass or fail it. And then if I pass it, I'm a certified paralegal here in the state of Florida. So that's pretty cool. I figure with all the legal filings I've been doing pro se, I might as well turn it into a profession. So why not?
So it's, it's another feather in your cap. And it's, one of the reasons you continue to do stuff like this is to prove to the world you're not what some people would claim you to be.
Yeah.
Right?
Yeah.
So-
Well, for starters, I've collected certificates my entire life.
Yeah.
So
Yeah, literally,
I've always been an overachiever.
We
in
found
school.
her mom's scrapbook of her stuff. So
yeah, honor roll certificates, all that jazz.
Everything going back to kindergarten.
I've always been an overachiever that followed me into adulthood, obviously. So any chance that I get to earn something to show that I am educated in a certain field, I'm going to do it. So becoming a certified paralegal not only helps myself, but it also allows me through my nonprofit, Justice for the Serlick Children, to help other pro se litigants that are victims of family court and CPS corruption, and hopefully be able to apply and get some grants to fund my nonprofit so I can offer pro bono services to these pro se litigants as a certified paralegal. So obviously myself, just like all the rest of us, hundreds of thousands of us across the nation, we have lost everything. Everything has been taken from us through these family courts. They throw insane amount of wage garnishments on us. They don't even look at our financial affidavits.
They don't even care.
They pick a number out of thin air, whatever sounds best to them, and then orders us pro se litigants to pay it, whether we have the financial means to pay it or not. So since September, my ex-husband, Justin Serlick, has been getting $1,700 a month since September through my teacher salary that's being garnished illegally here in the state of Florida. So Florida taxpayers in Orlando were literally paying my ex-husband, Justin Serlick, to continue hiding my children from me the last 9 months. So, nobody can say on the internet that I'm not paying my child support. It's literally being stolen from me, $1,700 a month. And where that's going, who knows? Because I have no contact with my children whatsoever.
Yeah. It's
who knows?
And we've seen so many people with similar stories that we've come across, and just the way the system has been built up to intentionally inflict damage to families is, most people that have never been into the family court system have no idea.
No,
I had no idea before.
And that's why so many of us
I've seen stuff firsthand.
Yeah. And that's why so many of us have a moral obligation at this point. It's a moral obligation
to speak out,
to educate the general public, to educate taxpayers on what their money is going towards, because ultimately these court actors are being paid by we the people, and they are harming we the people. So it is our moral and ethical obligation to whistleblow on what these people are doing to children and families across the nation. And it is my First Amendment right, my God-given First Amendment right, to speak out to the nefarious and egregious actions that these court actors are doing to families and children. And I will continue to speak up. And that brings me to my next update. So March 2025, I had put in my candidacy for not one, but 2 seats here in Florida for the 2026 election, mainly to make a political point at the Tallahassee Capitol building, live in Facebook, live episode, to explain what I was doing there and why I was putting in these statements of candidacy. Now, obviously, once you get to a qualifying period, you cannot be in more than 1 seat. So a few months ago, I did drop the Senate and I stayed in the Florida House of Representatives, District 30. Qualifying period is coming up next month. And because I have been crazy busy being a first-year teacher to over 160 high schoolers, I have not had the time to get out and campaign and raise money to pay in to the primary election in August. So I've got 1 week to raise $1,800 in my campaign fund. Otherwise, I will not qualify, and I will just have to wait until the next election in 2 years. But that's kind of where I'm at. Yeah. Why Florida House?
Well, one of the things that they're responsible for is making sure the other branches of government are doing their job. And so when a branch like the judicial branch is not doing their job and a constituent reaches out or tries to reach out,
Chase Tremont.
And then that representative doesn't even respond to emails, phone calls, the assistants don't respond. You sort of didn't really have any choice left, but you threw your hat in the ring to do it yourself.
But what is something that Chase Tremont can do in his position that can help us family court victims? What can House reps do? And why am I encouraging court victims to put their name in for House rep positions in their district?
In most states, the legislature, if they're, have two houses, which most states do, one house. So in this case, in Florida, the state House of Representatives, it's one of their duties is to file articles of impeachment against officials when they're not doing their job. And then once the articles are filed and voted on by the House, they move to the Senate, the Florida State Senate, for trial on impeachment. And some judges need to be impeached.
So why did I choose House over Senate? Well, because a House rep can put forth articles of impeachment. Senate is the second part of that. So first, a House rep needs to put forth the articles of impeachment, and then Senate moves to vote on it after House. So obviously, with me wanting to make sure that these judges and judicial entities are being held accountable, I wanted to go after House Rep District 30 because that's how I can make a real significant change in people's lives. And that's what I want to do. Not only do I want to help educate the public and the taxpayers on what is happening across the nation and here in Florida and Illinois, but I also want to be part of that change. And the best way for me to make real changes is to put my name in for House representatives and get elected as a House rep so I can put forth articles of impeachment for these judges that are violating our constitutional rights and our rights to our children and our rights to due process. There is a constitution for a reason. And I have always respected that document. I saw that document firsthand with my own eyes in 8th grade, and I will continue to protect U.S. citizens when it comes to our constitutional rights. And that means educating the public, taking a stand, and putting my name in for candidacy.
And with that being said, you've got a few days left to raise the money needed. If anybody does have the ability to, we certainly are not asking anybody, if you don't have the ability to contribute financially, please don't. But if you do have the ability, there's a QR code in the top right corner of the screen now. Please click on that. It'll take you right over to Heather's website, which is heatherbendel.com. And you can make contributions directly to her campaign through that website. Again, it's heatherbendel.com. We've got a few more days to try to raise the qualifying funds. But even if somehow we don't make it, this, I will say, has certainly been a learning experience for both of us. We've learned a lot of the steps and procedures,
the admin, the paperwork,
what you have to do.
I've got a
filing
bank
the
account.
financial reports.
Right.
And
That was just filing the financial reports. That was a learning curve in itself because I'm acting as my own treasurer, mainly because I don't trust a lot of people anymore. Wonder why. So when it comes to finances, at least if I'm doing the finances and I'm my own treasurer, I know exactly where the money is coming from. I know exactly where the money is going, because ultimately that bank account is linked to me. So I don't want any funny business. I am an open book and I don't need any weird activity, fraudulent activity, etc. So I just rather be my own treasurer. I helped small businesses for over 15 years in corporate America. That was part of my job. So payroll, taxes, etc. So I'm fully capable of being my own treasurer. But with that being said, if I don't raise the money this go around, you better believe as soon as the election is over, I'm putting my name right back in. And that gives me 2 full years to not only raise the funds, but also get my name out in the public more than it already is. And now bring more awareness.
And now we have some experience.
Exactly.
We
it's
figured
only
out
going to
how
make
to
it
get
easier
stuff done between the Yeah, I mean, it was a process just figuring out how to set up the donation system through the website, getting your website set up, all of that stuff. Because with the donation, there's rules you have to follow. Like here in Florida, you actually have to collect people's employers' information.
Right. So when I put in,
and then there's limits. You can't just like have one person give you $1 million. It would be great if you could, but
right. So when I filed the Q2 report and put in the $100 for opening the bank account, they collect all of that information and every contribution and every expenditure. So, open book, sunshine law here in Florida. I love it. It should be in every state, and it really should be a federal law. It's just everything should be an open book policy when it comes to people's lives. So, and that's
especially family court.
Yeah, that's going to be one of the best ways to keep people in check is things like the sunshine law here in Florida, where everything is public access, public records. Everything I do as a public school teacher is public access through the sunshine law. As a candidate, it's all public records. So I have nothing to hide. So that kind of moves on to let's talking about my petition for leave to appeal to Illinois Supreme Court, also known as a PLA.
Yeah. So what this is basically the way the courts have set up their procedures. You basically, when you get to the end of the line with the appellate court, so if the appellate court just dismisses your case, then you have your option. If they give you a written opinion, which in Heather's case, not only did they give a written opinion, then they did a modified opinion
after I requested the rehearing.
Yeah. So with that written opinion from the appellate court, you then had the opportunity to ask for permission to the Illinois State Supreme Court to have them review your appeal. And when you move it into the state Supreme Court, there has to be a state law issue that impacts, everybody in the state.
Right.
And you had that in your case.
Absolutely.
I mean, you had a couple things in there, but one specifically,
so just to catch people up. Yeah. So the last episode back in April, so a month and a half ago, the last thing we talked about was my denial of the petition for rehearing. And then they modify, like Pete was just mentioning, they modified the order from the appeal to reflect that rehearing. And then on May 11th, so almost 30 days ago, May 11th, I filed this petition for leave to appeal, this PLA to Illinois Supreme Court, and it was accepted. As always, this document and the next document we're going to talk about will be in a Google Doc link. And it does have stamped confidential on it, but that is more for Illinois Supreme Court, so they're not publishing this on their website. It doesn't mean that I can't talk about it or share the documents. I've already verified that with them. It just means that their coding in their system is confidential, so they cannot share it. But it is my document. I wrote it. I can share it. So don't be alarmed if you see confidential stamped throughout it. But the front is the standard cover page that Illinois Supreme Court law requires. And then we're just going to briefly talk about the argument, because a lot of this we've already talked about on previous episodes. But why are we taking this to Illinois Supreme Court? Well, we're going to talk about the argument. So this whole document is with the appendix, I want to say 100 and something pages, but the actual PLA is 35 or something like that. 35. So why don't you just go ahead and read the argument right there?
So basically some of this is procedural stuff, but for the argument, review is warranted because the circuit court dismissed the appellate court, or the circuit court dismissed and the appellate court affirmed dismissal of a section 2-1401F voidness petition without a merits determination of service, notice, personal jurisdiction, and due process. This case presents a question concerning the minimum procedural protections required before Illinois court may enter a final order that gives one parent sole custody or sole decision-making authority, 100% parenting time, custodian status, retroactive child support, and ongoing child support.
And then next page.
While reserving all parenting time and contact for the other parent. Section 2-1401F preserves the existing right to seek relief from a void order or judgment. Then it gives you the full state statute in Illinois. A petition alleging that a judgment is void for lack of personal jurisdiction or defective service is not subject to the ordinary 2-year limit applicable to other Section 2-1401 petitions. And then Heather's petition was explicitly brought under that, as it alleged the April 27, 2022 order was void because the final parental responsibilities and support relief was entered without a record showing valid service, adequate notice, personal jurisdiction, or due process. So that's one of the arguments. There's multiple.
Yeah.
So that's what ties it in essentially to the requesting that the court void the order, which was what all of this started as from your petition. One of the other big things that you point out.
Did you read that part? Because I was going to read this. The beginning of that sentence.
But that reasoning did not answer whether.
Yeah. Respondents' September 2021 petition sought new or additional affirmative relief against Heather, requiring valid service and constitutionally adequate notice before final relief could be entered after her non-appearance. The April 27, 2022 order did not merely resolve Heather's earlier finding. It granted respondent, Justin Serlick, affirmative relief, including sole decision-making authority, 100% parenting time custodian status, retroactive child support, and ongoing child support. And that's where that $1,700 is stemming from, my being garnished from my teacher salary here in Florida, is all based on this April 27, 2022 3-page order that is completely illegal.
Yeah.
And they know it's illegal.
And I mean,
and they're protecting themselves.
We laid it out pretty clear, both to the appellate court, we thought, and even more so to the Supreme Court in the PLA. So that's one of the argument, issues. The another issue and this brings up concerns for statewide issue, was the fact that the appellate court basically was talking out of, both sides of their. Well, I won't say it, but. They're basically saying the UCCJA, which we've talked about a lot before, but Uniform Code for or Uniform Child Custody Enforcement or Jurisdiction Enforcement Act. It's the statutory law, that's the statute in 49 out of the 50 states that tells states how to deal with child custody cases that might be going between states. So it is the law.
Right.
Okay. It is not a suggestion. It is the law.
But we all know they're not following the laws. They're just doing whatever they want.
Well, the appellate court is trying to say that the April 27th, 2022 order is still valid because UCCJA is just a procedural hurdle. And the court had jurisdiction because their constitutional authority allows them to decide anything that is justiciable, is the way it's worded in the Illinois Constitution.
Except
now, flip that
supremacy law.
Flip
supremacy
that. No,
clause.
Stop. Flip that. So here they're on one side they're saying back in April of 2022, the court, even though they didn't have jurisdiction because of the UCCJA, that didn't matter because the item was up before the court and the court could make a decision on it. So they could. Now in 2025, now it's 2026, but this started in 2025. The court dismissed it, saying they don't have UCCJA jurisdiction, but
they didn't have it back in April when they wrote that order in 2022.
But
they completely lost it the moment I transferred my driver's license to Florida.
Again,
they had no authority over me.
Okay, but back in 22, they're saying UCCJA doesn't matter. Now they're saying, well, we can't decide anything. We can't even hear this case because of UCCJA. You can't have it both ways.
But I already went to Florida first, and Florida District 5 Court of Appeals literally said they don't have jurisdiction. So we went to Illinois, and now Illinois is saying they don't have jurisdiction. Florida says they don't have jurisdiction. Illinois.
And here's the thing:
what is happening
in both
hang
states.
on. This is what is happening to thousands of families across the nation. This is not a one-off. I thought my situation was a one-off. Hugh and Christine talk about this on Judgmental Podcast all the time. These are no longer one-offs. I now know many people across the nation that are stuck between two states with UCCJA, Beth being one of them, and she's the one that taught us about UCCJA, and she's dealing with this exact same issue where one state says they don't have jurisdiction, so you go back to the other state, and then the other state says they don't have jurisdiction, and then both of them are refusing to do anything about the orders.
It's a can of kick the can down. It's a game of kick the can down the road.
It's a game of we have put you in legal purgatory on purpose to keep you from your child.
Yeah. Yeah.
And that is all sorts of illegal and all sorts of unethical practice of law.
It really shuts down paths forward for families. And
it's disgusting.
This was one of the,
and who ultimately pays the price?
It's the kids.
The children.
And
there is no in the child's best interest involved in these situations where both states are refusing to take jurisdiction. The children always lose. That's it. I'm not losing. Justin's not losing. It is ultimately my children are losing everything, and they have been they've lost everything since this began in 2020, and they haven't gotten any better. Bianca, once again, end of year, I'm waiting for her final report card. I know we talked about this on the last episode, but Bianca is not doing well. She's 14 years old and she can't read or write, but somehow Illinois and Florida thinks this is in the best interest of my children. It's not. And they don't seem to care about the children. They care about who gives them the most money behind the scenes. And then they also they care about protecting themselves, because ultimately that's what's happening at this point. Why am I going to these extremes of moving up the chain of command and now going to federal? To show the complete breakdown of our judicial system.
You kind of just dropped a big bomb there. You just didn't even lead into it. You just that you filed a federal lawsuit.
Oh, well, everyone already knows, and we'll discuss that a little bit more. But yeah, I did file a federal lawsuit. We'll discuss it a little bit more, but it's the first of many. And all of us need to be going in federal court to deal with these jurisdictional issues that the states are forcing upon us and ultimately destroying lives, playing with the UCCJA game. That 49 of the 50 states are required to follow UCCJA. They signed into that agreement, but they're not following them on purpose.
And in Illinois, there was another court case, I think it was McCaskill, that basically flipped a UCCJA decision, which is now precedent, so that basically allowing the courts in Illinois to ignore UCCJA just because the Constitution says they can decide stuff.
Except there is a such thing called the Supremacy Clause.
Well,
and regardless of what your state law is, nothing supersedes the U.S. Constitution. And if you're violating 14th Amendment, Troxel Granville, that law didn't come out 100 years ago. That's pretty recent. It was 2001.
And that's part of the arguments that you've now raised first to the appellate court, but now to the Supreme Court, is that, the order in your case was so short and vague that on its face, it's not even considered a parenting order. And that's one of the infuriating things when we were reading.
It's a 3-page order.
Well, when we were reading that
reserves rights. And in Illinois, that's illegal. They can't reserve rights.
When we were reading the appellate decision, the appellate court kept referring to it as a parenting order. But it's not,
because I still feel like you have not had the veil completely lifted off your eyes, because the way you talk like, oh, they're just not seeing it the right way. They know exactly what they're doing. These people went to law school. They know the laws. They're choosing not to follow the laws because they are helping people that are giving them campaign contributions or, you know the right people. It's all about the connections, and everybody knows this. This is, it's all George Carlin. It's all one big club and we ain't in it. He said it best. It's one big club and we ain't in it. All right. So moving on. So once I filed this, I had 5 business days to get 13 printed and bound copies to Illinois Supreme Court in Springfield,
physically
Illinois.
delivered.
Yep.
13 copies.
13 copies. So
Sent them on a carrier pigeon.
The next document that you'll be able to look at is called a correspondence. So this is basically me just saying, please take notice on the 13th day of May, 2026, the undersigned has mailed the following documents to the clerk of the Illinois Supreme Court via UPS and respondent Justin Serlick via USPS. 13 bound copies of the PLA and appendix with attached UPS tracking number, blah, 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 and should arrive by Monday, May 18th, 2026, which it did. 1 copy of the PLA to respondent Justin Derek Serlick with the attached USPS tracking number of blah, 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 to his home address of 333 South Landvale Avenue, Daytona Beach, Florida, 32114. The PLA and appendix arrived in his mailbox Friday, May 15th, 2026, and the PLA and appendix were also directly emailed to him as well as served through the Illinois Odyssey portal on Sunday, May 10th, dated May 17th. And then it has the tracking information of both. So this is just to CYA. Hey, guys, I sent it to you. Here's the tracking numbers. Justin has it. Here's the tracking number. He received it. Here's proof. So that is pretty much it for the PLA. Why did we wait so long other than just that we're stupid busy? Because Justin had until Friday, June 5th. Yesterday to file his response. Once that 20-day time is up, which was Friday, it then immediately goes in front of the panel of justices at Illinois Supreme Court. So. However, there is not, even though this is accelerated under Illinois Rule 311A due to custody and care of children, even though it's accelerated, they did confirm that there's not a set time frame for the justices to decide in the PLA.
But then the other big thing here is, remember what I said. This is just a permission slip to actually appeal. This is not the actual appeal.
Right.
You do have an option in Illinois to check a box and say, just use the same document as the appellate brief also. Or you have an opportunity to file.
So the next step is the justices look at my PLA, look at the appendix I attached, look at my argument and say, yes, we will allow this petition for leave to appeal. Go ahead and either tell us that you are going to use the PLA as your brief, or if you're going to file a new brief, which is what I will be doing, I will be filing a new brief.
Because we've actually uncovered new information too.
Right. So. But the next step is for them to either approve or deny my petition for leave to appeal. If they deny it, I'm done. There's nothing else I can do in Illinois Supreme Court other than extraordinary writs, which that is something I'm more than likely going to be filing if this PLA is denied. If it is actually approved, then I will be filing a new brief, and then Justin will have a certain amount of time to respond to that brief, and then it goes back in front of the justices for them to review the brief. But if they deny it, it's the end of the road for this PLA. It's done. It's dead. So I am looking at a few extraordinary writs to file directly into Illinois Supreme Court if this is denied. So that's pretty much where we're at with Illinois. So pretty much all that's left to talk about is my federal case, which we already touched on. May 31st, so just 7 days ago, I filed my first ever 42 USC 1983 with added, if needed, 85 and 86 complaints.
And ADA.
Yeah, and ADA violations by Illinois Circuit 19. So we're going to be discussing that on episode 10. So just stay
But-
tuned for that. I don't
but
want to go into any more details about that right now.
Yeah, the only thing I'll add to that is, again, some of this this whole process has been a learning experience between your campaign, between working the case, understanding the different rules and processes to get it up through the different court system. It is so easy to understand how your average parent out there that gets stuck on the bad side of family court gets completely lost and gives up.
Yeah.
Because you've been at the point of giving up a couple times.
Yeah. Yeah. And the only thing that keeps me going is my children.
And the system is designed to get people to quit.
Oh, this goes so much deeper than even that statement. This is absolutely a difference of classes of society that is crushing the lower classes. This is absolutely, when you really look at the overall big picture of this is a redistribution of wealth where attorneys, judges, the wealthy literally walk all over the less wealthy people, take everything they have, their home, their savings, their retirement funds, their pensions. Arnold Yan knows that. His pension was stolen from him. They are absolutely trying to destroy the lower classes, so all that's left is upper class. And that is, by definition, Margaret Atwood's Handmaid's Tale. That is, by definition, George Orwell's 1984. Fahrenheit 451. Like, there are so many authors that have been warning society about this for a very long time, and we are actually watching it happen. We are experiencing it. And what is it going to take to get them to stop?
Yeah.
It's going to take we the people running for office, being whistleblowers, educating people, the general public, the taxpayers, and using our voice, using public speaking platforms, lawsuits, federal lawsuits.
And that's one thing.
Doing interviews
with again, going back to your federal lawsuit, to some extent, a bit of a learning experience, understanding the process, understanding each court, each district court has a different process, but you're also going to be sharing the knowledge that you've uncovered with other people to help them move forward. But here's one last point I want to make on the topic of the federal lawsuit. This has just been, the first go round.
Right.
You're getting better at every document you file.
Well, so the federal lawsuit I just filed.
There's people out there that have been continuing to violate your rights. 14th Amendment, right to parent. And
that's been nonstop since 2020, October of 2020. That has been nonstop, that my 14th Amendment has been violated via Troxel Granville.
Yeah, and those are coming.
Yeah. This federal case I just filed in downtown Chicago at the Northern District, that was a small lawsuit. The one that I have been building since the beginning of this saga in October 2020, that is going to be massive. So this one I just filed was my trial run, so to speak, on learning the procedures of that court, because my next one is going to probably have over 40 defendants. It's that big. And it's going to be a lot of coordination of getting all these documents served to people, that defendant list, and keeping everything organized. So this kind of mini side quest that Illinois has forced me into, and we'll get more into that in episode 10, this side quest has actually been educational for me to put forth what I learned in this bigger one that I quite literally have been collecting texts, emails, communications, evidence for 6 years now. October will be 6 years. So we'll talk about that more in the next episode to come, probably later this week, because we want to continue trying out this new software that I'm checking out with StreamYard.
Yeah, which
if you use StreamYard, please leave comments. Let me know what you think. Any tips, tricks.
Yeah.
This is our first time using it. I'm on a trial.
I think this is really cool. I've had the YouTube live up on my phone, so I've been watching it. It's been a steady, good stream. We're getting comments. So Reverend Rasheem Stewart, we can put this up on the screen, left a comment, vote for Heather Bendel.
Thank you.
So we need to get her on the ballot first. So
right.
Again, if you can, visit heatherbendel.com, make a contribution if you're able. And then we also had another viewer, Elizabeth Knight, left us a comment. Null and void without prejudice, UCC 1207-308. So I'm not sure that exact statute. We have to look it up to see what that refers to, but we appreciate everybody that's been, that watches, anybody that leaves comments. Please like and share.
Please share this live. If you're watching on Facebook, please share. We, the people, need to come together. I really want to see in the next year or two, I want to see family court and CPS victims putting their statements of candidacy in for their local House of Representatives position. Even if you have no idea what you're doing, it gives you a spotlight to get your story looked at, because I'm telling you, once people see your name as a candidate, they start Googling your name, they start researching you, they start looking at what's going on, who this person is. You will get eyes on your case. If that's what you want, that will be a great way to get eyes on your case, putting in your statements of candidacy, and use that first go around as a learning experience.
Yeah, it is a process. Don't get us wrong. It is not meant to be easy. It is not for everybody.
If it was easy, everybody would be doing it.
Yeah, but
it's not for the faint of heart. You are going to be put in a political spotlight by putting in your statement of candidacy. So you first need to understand the repercussions of that.
You've been contacted by 2 or 3 reporters at this point.
I have. I have an interview coming up this week with a news station.
Yeah, you've actually met with other candidates running for other offices.
That's actually another good point. Because I'm a candidate and because I've been going to political events when I can, I've been so stupid busy. I have met a lot of other amazing grassroots candidates like Sarah Ulrich, who is running for Congress to hopefully replace Corey Mills. So I have now met and spoken with Sarah many times. Her sign is in my yard. I've met a bunch of other local candidates.
Well, you've met Jake Johansson, who's and Jason Bowles, who are both running for the same Florida House or Florida State Senate seat.
Yeah, Senate, which I dropped. Jason Bowles, ironically, was and I think he still is, a family court victim with child support, garnishments, etc.
Yeah, he came up to you and said, "I know exactly why you're running. I'm running for the same reason."
Yep. Because we are seeing and experiencing these egregious violations of our constitutional rights. And when we, the people, have had enough, this is what we do. We step up to the plate, put our name in, and fight the good fight. So please, please, please consider doing that in your next election, House of Representatives, because that is the position that in almost all states can bring forth articles of impeachment against these corrupt state actors.
Yeah, because as anybody that's tried the judicial qualifications commissions,
it's a big club and we ain't in it. They're all protecting each other.
Nothing ever really meaningfully happens. And
no, because it's like the bar. You pay into it as a member and then you get protections by the bar. Yeah. Here in Florida, it's called JQC, Judicial Qualification Committee. I filed JQC complaints, and 6 weeks later, I got letters in the mail saying this isn't worthy of an investigation, dismissed. They didn't, nothing. I'm literally giving them evidence of what these judges are doing to me, and nothing. So that is a big problem. Like I said, it's a big club, and we ain't in it.
Yeah, and you've also filed notices of judicial misconduct in Illinois
Mhm.
against 2 judges.
Mhm.
That they're just straight up real documented evidence.
There is
of,
literally
you
no
know, issues
oversight
going on.
whatsoever.
So, but that's it, I think.
Yep. I
Good
wanted to
Saturday
keep
night
this. I wanted to keep this
podcast.
under an hour. So I appreciate everyone that either tuned in live or listens to this or watches this after the fact. Let's keep pushing forward, everyone. Mark Ludwig in our team is going to be in DC in the next few weeks, the last weekend of June going into July 1st. We unfortunately will not be able to make it. The trip is just way too expensive for us, and gas prices have just been killing us with me driving to Orlando for work.
And it's also overlapping with a conference I have for work.
Yeah, so. your 4-day summer regional. So it literally overlaps each other. So unfortunately, we will not be able to be in DC with Mark and the team. I was really looking forward to Pete joining me this time. But hopefully in the fall when they go back again, I will have some more funding for that. And then we definitely need to arrange another protest here in Florida. I think it's well overdue for another protest at the Daytona courthouse and District Court of Appeals.
Yeah, but I don't know. Maybe wait till the winter when it's not 600,000 degrees outside.
Well, what I mean is I want to start planning ahead, so we're not like 2 weeks in advance, trying to plan it. I think I want to.
Stupid hot.
I think and that was in September. But I really don't want to wait an entire year and a half to do another one because I organized that Daytona one. So if you are local in the Daytona area, let me know if you want to organize another protest with me. And we'll have to start figuring it out. June, July, August are the stupid hot months of the year here in Florida. So let's get this planned out months in advance so we can get flyers out and get a coordinated national protest going again. Let's go, guys. Let's keep the momentum going and let's keep educating and keep moving forward with our court cases. My name is Heather Bendel.
And Pete Arnold.
You have a great rest of your night. Bye, everyone.
Take care.
Shadows find the family court. They bury the truth, they cut the support. Corruption thrives where the silence stays. But we're lighting the fire to burn down the maze. We are the voice for the voiceless. We are the voice for the voiceless. This is the Justice for the Serlick Children podcast.
The content of this episode is for educational and advocacy purposes only. All statements made reflect documented filings and communications received by Heather Bendel and the Justice for the Serlick Children team. We encourage all listeners to form their own conclusions based on the evidence presented. No accusations are made without supporting documentation, and all persons are presumed innocent unless proven otherwise through due process.